Hey, wholesalers, tell me if this has ever happened to you. You find a great deal, you get it under contract with the seller, you find a buyer who's willing to pay your assignment fee, and then right before closing, the seller or the seller's attorney start asking you questions. Like, who's this? Why are they buying my property instead of you? And why are you getting a fee for them buying my property? And then they try to renegotiate the deal or back out altogether. If this has happened to you, or if you're worried about this happening, in this video, I want to tell you about a strategy that you can use utilizing legal entities to avoid this problem in the first place. Find out what it is coming up. Hey guys, my name is Vitaly Volpov. I'm a practicing attorney, an active real estate investor, and a part owner of a real estate brokerage in upstate New York. On this channel, I discuss relevant legal concepts as well as best strategies and tips for real estate investing. If you're new to the channel, consider subscribing and hitting the notification bell so that YouTube notifies you of all my future content. If you enjoyed the content in this video, hit the like button and comment down below. And as always, whenever I'm discussing legal topics in my videos, just know that this is not legal advice and you should always consult with your own attorney and your own advisor before making any legal or financial decisions. Additionally, the views and opinions that I express in this video are my own alone and don't necessarily reflect those of my law firm or any of my business partners. Alright, so with that out of the way, let's go to the whiteboard and talk about the strategy. Alright, so let's first talk about the typical wholesaling deal. And in a video I did a couple of weeks ago, I talked about two different types of wholesaling that exist. The first type is a double close, where you go out, you find a property, you get it under contract with the seller, you get your financing, you actually pay the seller the amount you agreed to pay them, and then you immediately turn around and you resell that property for a higher price to another investor. And so that's a double close. You actually take title to the property in that scenario, and then you transfer title to another investor. That scenario doesn't actually implicate the issue that I described in the beginning of this video, because there it doesn't matter. The seller doesn't care what you do with the property after you pay them the amount of money you agreed to pay them, and so it's not really an issue. Where you run into an issue is with the other method, the more popular assignment of contract method. And this is where you get a property under contract, you don't close on that property, and you simply go and you assign your right in that contract to another investor for a fee. And what happens in that transaction is that a lot of times the seller will know that you're making a profit and they will know that you're not the one buying this property. So let's look at an example just as a basic assignment of contract situation. So this is you, the wholesaler. You found this property, you go and negotiate the price with the seller, you enter into a contract with them, and let's just say, you know, this is $100,000, let's just say, for even numbers. That's the price that you agreed to pay the seller for this property. The next thing that you're doing is you're shopping the contract around, you find a buyer, and the buyer maybe is willing to take over the contract and pay you a $10,000 assignment fee. So you enter into a separate contract with this buyer, which is the assignment agreement. And then when it comes time to closing, the buyer steps into your shoes, they pay the seller, they get title, you get the $10,000, and everyone walks away happy. Or at least that's how it's supposed to go. But typically when you have an attorney representing the buyer and you have an attorney representing the seller, the attorneys have to provide the parties with a closing statement which goes through all of the costs and expenses and prorations and fees and everything else that's involved in the transaction. And a lot of times this $10,000 fee will be reflected in that closing statement. So if the seller is represented by an attorney, that attorney is going to see that, well, first of all, the buyer, in this case, is not you, it's this other party, which is not part of the contract with the seller that the seller's attorney has seen. And they'll also see that you're making a profit, the $10,000 on the side. So they're naturally going to explain that to the seller, and the seller might get upset and cause a problem. And of course, at this point, the seller probably doesn't have a legal right to back out of the contract, but that doesn't mean that the seller won't delay or will not try to renegotiate the deal. And the problem for you is going to be that the buyer might not stick around, or maybe the buyer will think, well, hey, maybe I'll just deal with the seller directly now that I can see that the seller is upset and is trying to back out of the main transaction. So all those things create problems for you. So how do you go about solving this problem if it comes up? Well, you do that by actually structuring this transaction completely differently. You can do that by entering into this contract not as yourself individually, but actually using an entity, a legal entity, to buy this property or to offer to buy this property from the seller. And what a lot of investors do is they use an LLC, or sometimes they'll use some kind of a corporation to do this transaction. And the thing that you can do to avoid the issue of disclosure to the seller is, instead of assigning your right to this contract to the buyer, you will simply sell your membership interest or your interest in the entity to this buyer. So with an LLC, you have a membership interest in this entity. So maybe you're the sole member of this entity, so you own 100% of this LLC. So instead of assigning the contract, you will simply enter into an agreement for the buyer to buy your membership interest in this LLC, and it could be for the same price. So the amount of money that's exchanging hands doesn't really change, except what changes is that this part of the transaction is never disclosed in the closing statement to the seller and the seller's attorney, because it doesn't need to be. Because the party that originally contracted with the seller to buy this property is still the same entity. It's the LLC. It's just that the LLC's membership, the ownership of the LLC, has now changed, but the seller doesn't need to know about it. Now, this sounds like a great solution, but there are actually quite a few problems with this strategy. Problem number one is that in order to do this, and if you're going to do this multiple times every year, or maybe you do it 5 times a year or 10 times a year, or however many times, you're going to need to set up a separate entity each time you do this type of transaction. Because at the end of each transaction, you're no longer the owner of this entity. This entity went to the buyer, the ultimate investor who ends up closing on this deal. So this means that you have to spend money to create this LLC or corporation or whatever you're using every time. And depending on the state that you're in, and this is very important, this might end up costing you quite a bit of money. Some states, like New York, are pretty cheap. If you did it with an attorney and you're going to be a sole member of the LLC, you could probably do it for $1,500, maybe $2,000, maybe less, depending on the area you're in. You know, if you're in the big city, New York City or something like that, maybe it's going to be more. But you could probably do it relatively inexpensively. There are also, of course, LegalZoom or other online ways to set up your LLC, which might cost you even less. Not necessarily recommending that, but that's a topic for a separate video. But you can do this, and it might not cost you very much in New York. If you did it somewhere else, maybe you did it in California or something, where they charge you franchise taxes, they charge all kinds of additional fees, or other states in the country, this might cost you thousands of dollars, and even if you did it without an attorney. So cost is definitely a concern with this strategy. The other issue with this strategy is that when you're entering into this agreement with the buyer, you're still not insulating yourself from liability. So even though you have an LLC that's involved in the transaction, you're not fully protected, because you personally are selling this buyer personally the membership interest in this LLC. Now, one way to solve this problem is to have another entity who's going to have the membership interest, own the membership interest in this LLC. And what a lot of attorneys and tax professionals and asset protection attorneys recommend is that you use something called a C Corp as the entity that owns the membership interest in every LLC you use for all of your wholesaling transactions, and you would own the shares and control this corporation. So you have the corporation that owns the membership interest in the LLC, and then you have a shareholder interest in the corporation. And the benefit of this is that when you go to assign your membership interest in the LLC, the contract you enter into for that assignment with the buyer is done through your corporation. So that if something goes wrong with this contract and the buyer wants to sue you, well, they can only sue your corporation and not you individually. So you're actually giving yourself another layer of liability protection and still accomplishing what you're trying to accomplish here, which is not alert the seller to the fact that this is an assignment of contract. Again, there's still the problem of cost with this, and the fact that, this is a pretty complicated process, and it's not always easy to set up an LLC unless you have legal advice. And if you are doing this with, legal representation, it might cost you a substantial amount of money, so that maybe that $10,000 that you would have earned if you were doing this in your own name and taking the risk that the seller might have a problem with it, now becomes $5,000 or less, making it a lot less attractive for you to do this. So one way some attorneys recommend to deal with this problem, the problem of cost of having to set up a new LLC every time, is instead of an LLC, by entering into this contract using a trust. And some attorneys call this a land trust. So instead of an LLC, what you would have is you would have a trust, which does not need to be recorded with the Department of State in the state that you're doing business. And you don't actually need to file anything with the trust. It's simply a private document that allows the beneficiary of that document to transact business using a trust. So you could use a trust, which is going to be a lot cheaper for you to set up, and you can have an attorney who can form several trusts for you that will all look identical except for a few features of the trust. And then you can use those trusts in multiple transactions, one for each transaction, specifically filling out the parts that were left blank, and avoid the cost of having to set up and file an LLC every time you need to do this. Thereby, you can reduce the costs of this whole process and still accomplish the purpose that you're trying to accomplish, which is to keep the seller from knowing that this is an assignment of contract. Now, I know this sounds complicated, and if you guys have questions about this, drop me a note, leave me a question or a comment down below. I'm happy to answer it. If you guys want to go a little bit deeper into this, or if you need legal representation, if you are doing business in New York, feel free to give me a call or send me an email. I'm going to leave my contact information to my law firm profile in the description below, so you guys can reach out to me that way. And I'm happy to answer any questions that come up. This is not, your garden variety wholesaling strategy, but it certainly would make things a lot easier for you in the sense that the seller won't be backing out, the seller won't have the same issues with the transaction, and if you have a good attorney on your side who can help you set this process in motion, you'll be able to repeat it and be able to reduce your costs going forward. Thanks for watching this video. Have a great day, and I'll see you in the next one. Take care.